introduced, I'm John Leeming from Kemp, patent attorney. I largely specialise in software and semiconductor manufacturing and a bit of optics and things. So what I'm going to do here is give an introduction to patents. So I'll give an introduction mostly to patents, but briefly touching on some of the other intellectual property rights that might be relevant. Patents tend to be regarded as a gold standard of intellectual property and most often the most valuable for a startup or early stage company. So the first question really is, why get a patent? Well, as mentioned earlier, a patent can provide a concrete asset that an investor is prepared to put money in. The reason it does that, it can protect whatever competitive advantage, whatever technological advance your company is relying on, maintain the uniqueness of your key features. For the bigger companies, it often turns into a sort of bargaining chip for cross-licensing. And for UK companies at the moment, there's a thing called a patent box, which can help with reduction of tax when you get to the profit-making stage. For the inventors, there's a lot of, sort of kudos, and people tend to claim their granted patents on their CVs quite often. So, there's some fundamental principles. Now, many of you may already know this kind of stuff, but I thought I'd start from the basics just to be sure. So a patent is granted for a novel, that is a new, non-obvious invention. Non-obvious is, in some respects, quite a low bar, but there must be some kind of invention to it, some inventive step. It doesn't have to be earth-shattering, but it has to be a significant detectable advance on what is done before. Inventions really are aimed at technology, but across all fields of technology there is supposedly sort of unified law, but some differences of practice. So the key point of a patent is that it gives you the right to prevent others using your invention, as defined in the patent. Now, if you've got the right to prevent somebody using the invention, that means you've got the ability to allow them in return for money, shares, whatever the license is. So that's the fundamental point of a license. I've got the right to refuse you entry, but I'm going to let you in for a fee. Adam mentioned the need to carry out FTO searches. That arises really because a patent is not a permission for you to use your invention, it's just the right to exclude others. And that means that other people may have earlier patents with broad scope that you could be infringing. So you do need to sort of carry out some searching sometimes to check that situation and make sure you won't be falling on other people's rights. Now, it's a much cheaper job than it used to be with some good search tools these days, but it generally needs to be carried out by a specialist searcher. Spending half a day on Google Patents is not going to get the thorough result that you need for an FTO search. A patent is highly territorial. There are schemes that enable you to get patents in multiple territories at once, but ultimately you have to have a British patent, a German patent, a Spanish patent, a US patent, a Japanese patent, depending on where your market is and where your competitors are. So the geographic coverage of different companies varies. Big electronics companies go for Japan, Germany, France and the UK, and Europe, the US, China and other manufacturing places. Car industry puts patents in places where they make cars, which is Sweden frequently and other places that aren't so obvious. And the drug companies go everywhere, but that's exceedingly expensive. And the final point is one that is often overlooked, and that there is supposedly a quid pro quo for granting a patent, and that is that you have to disclose your invention to the general public in sufficient detail that they can make use of it. It's not a difficult burden to meet, but it does mean that you can't sort of hide crucial details, and it can be an issue in relation to drugs where they're claiming an invention in treating a particular disease, then have to prove that they can treat that. For electronic software type invention, the disclosure burden is not hard. Other intellectual property rights, registered designs protect the appearance of the product and just aesthetics, not function, and they tend to be a kind of late stage right. There's not a lot of point in getting registered designs until you're practically at the manufacturing stage. Some of you may have read about the Apple and Samsung fights about the designs in the iPad. Well, one of the reasons that Apple lost that one is that their design was an early prototype, which was actually quite thicker than the finished product, and that was a point of distinction from Samsung's products. Trademarks protect the names or the logos that will ultimately identify products or services as coming from a particular source. And again, that's potentially quite a late stage in the process, although a trademark is usually pretty essential for any trading company. Now, the first two of these, registered designs and trademarks, along with patents, are what are known as monopoly rights. So once you've got the right, you've claimed your territory, then somebody infringes that no matter how they arrive there. And it doesn't matter if they come up with the same thing themselves, you've got a true monopoly over that area. Second two, copyright and the design variants of copyright, unregistered design rights, only protect you against copying. So if you have your piece of software and your source code is protected by copyright, so somebody can't directly rip you off, and that's what you use for takedown notices if they're ripping your app off in a store. But if somebody writes their own software that does the same thing, but they've started from a blank piece of paper and can prove it, then they are free of your copyright. Trade secret is not, in a sense, a well-defined right, but it is an approach that some people use for a certain level of detail, that if you keep something secret, then somebody else can't do it. But again, if somebody works it out for themselves, there's nothing you can do about it. So, novelty. A very core concept of a patent, you have to have something new. And novelty is judged against everything that has been made available to the public prior to your priority date. And we call that the prior art. So whatever it is by way of publication in another patent application, scientific papers, products that are on sale or use, technical standards, all count as prior art. When you get into the patent process, then most prior art turns out to be other people's patent applications, and that's because the patent applications are well classified and easily found, but other kinds of publication legally count just as well. One sort of limitation on that is that a prior art disclosure must be enabling in order to count, so that there must be sort of some depth of disclosure behind that. If you actually manage to invent a teleporter, then Star Trek transporter beam is not prior art because it doesn't teach you how to actually do it. My little footnote just sort of says there are some exclusions in some countries, and it is slightly more complicated, but I won't go into that in detail now. Priority date that I mentioned is the key to your family of patents, because ultimately you'll probably end up with a family of patents, and that is usually the date of the first application that you put in for an invention in whatever country, usually your home country. Sometimes you can get sort of complicated families of patent applications where you make multiple applications and the priority date for different things can vary. But the key point is to establish your priority date before anybody else and before your own publications, because your own publications count against you most of the time. And that priority date is not the date you disclose it to me, it's the date the patent application gets written and reviewed and actually filed at the patent office. And it's very important to get that as early as you can, subject to getting a decent job done. Sometimes it is necessary to disclose inventions before a patent application has been filed, and you can do that if you get a non-disclosure agreement with the person you're disclosing to. It doesn't have to be complicated. Some people, especially American lawyers, produce pages and pages of boilerplate, but a fairly simple statement is that the person receiving the information understands that it is confidential and promises not to disclose it, will suffice. Ideally, it's sort of put in writing before the disclosure, but sometimes you can agree things after the event or infer it from the circumstances. An NDA may well be two ways, and that you agree not to disclose whatever the other guy's telling you. And it's usually limited in time. There is still a certain risk to disclosure under an NDA, because if the person does breach that agreement, then that second disclosure can be a problem, and you may not know that happens until too late. So it is it's possible, but preferably avoided. Inventive step. So this is the sort of converse of non-obvious. If something is not obvious, it has an inventive step. If it has an inventive step, it mustn't be obvious. It's all a bit of a legal fiction, and it is relatively subjective. And different patent offices around the world have slightly different sort of standards and approaches to it. The UK Patent Office is relatively easy. The US Patent Office is a bit random in my view. And the Chinese Patent Office is surprisingly hard. But you have to be able to show that some kind of spark went into the idea, that a person skilled in the art, one of your competitors, one of your peers really, but an unimaginative researcher in the relevant art, couldn't have come up with this idea just on what was known in the past. Because it is very relatively subject, it tends to be a thing that we get to the point where we say, well, probably, but the only way to find out is really to push it and see. Technology. A patent really does need to be based on some kind of technical idea. And again, the exact approaches of different patent offices around the world vary. The UK IPO having been lenient on inventive step tends to be very strict on whether your invention is technical at heart. The EPO and the Japanese Patent Office are fairly reasonable, and the US PTO has been extremely lenient in granting all sorts of patents to non-technical things, but now seems to be heading closer towards the EPO approach. So what is not technical? The word technical gets bandied around a bit, and we probably all think we understand what technical is, but that's not always good enough for lawyers. And so there are various different sort of approaches to trying to decide what is technical. So what is unpatentable? Business and administrative methods. abstract mathematical methods, rules for games, presentation of information. I've sort of lumped them in, but they're excluded on slightly different grounds. But methods of diagnosis and medical treatment aren't patentable. In terms of things that are done on a computer, and these days increasingly amounts of everything is done in some way on a computer, particularly if you consider all of the sort of embedded processors and stuff is a computer. And so the use of a computer per se doesn't make an invention unpatentable, but you have to look through the computer and work out what it is that the real invention is. So, where software-related inventions, what can you protect? So a computer program that performs a new technical process, any kind of image processing, optical character recognition, image recognition, compression, encryption, error detection, control of a machine. These things are all very easy. Nobody will blink an eye. It's patentable. If you have got a non-technical method that you're implementing, then it may be that there's something patentable in that implementation. So there we would look to the specific structures of the architecture of the arrangement, the hardware, the files, the order of processes. We do patent applications for kind of big data applications, bioinformatics, online searching, that kind of stuff, where the order of processes makes a huge amount of difference to the total computational load, and that kind of area is very patentable. Something that makes the computer itself better, faster, more reliable, more efficient, really comes down to things at the operating system level. So not so long ago, Apple had a patent upheld to a way of passing the sort of signals from touching the screen through to the apps, and whether you recognise double touches or single touches. And so that was held to be a patentable invention. So again, I cannot offer a definition of what's technical and what's not technical, so I always find myself coming down to examples. So on the technical side of things, again, sort of data encoding, OCR, database structures, digital rights management, audio and video processing, all very patentable. Things that are not technical, advertising, aesthetics. Apple had a patent, or tried to have a patent, for the way that their windows sort of expand out of the bar at the bottom rather than just blink into view. And that was rejected as just an aesthetic improvement. There was nothing technical about it. It looks pretty for the users, but it doesn't really make any difference. Sort of licensing schemes, I mean, I've said DRM is technical, but if your licensing scheme is, well, I can lend it to 2 people for a week each, or 1 person for 2 weeks, that's not technical. And if your scheme about whether you charge different rates for different tasks, this is kind of not technical. Lots of people have tried to patent various things about, turn my mail notification off, patent billing schemes for mobile phones. Lots of people have tried to patent methods of predicting stock and futures and currency movements. And I always think that if these methods really worked, they'd probably just use them and not try and patent them and publish them. The borderline, of course, is always the difficult one. Logistics, route planning has often been patentable, but then sometimes if it's too much about cost or too much about arbitrary choices from a business point of view, then it's not. Trading and exchange platforms have been patentable where there is detailed implementation, but sort of the idea of a reverse Dutch auction, not patentable. And again, user interfaces and display schemes can be patentable if you can show that there is some sort of real usability improvement or processing improvement. But if they just look prettier, then that's not going to help. Oh, I turned my Bluetooth off now, haven't I? So that's so when we're talking about invention in the implementation, we need a bit more than just sort of do it on a computer. And there are lots and lots of American patents you'll see around that say, here's a nice business idea, and we computerized it. But they are unfortunately now all being, or fortunately from one point of view, they're all being rejected by the US courts going. So if we're trying to say that our invention is in the technical detail of an implementation, we need to put all of that detail into the patent application. And we need to think about which is the clever bit of it. Show the advantages and how it does. And another key point is if the implementation is more useful generically than the specific business method that you started from, then that's a good sign of patentability. We can use it in multiple places. So other good signs of things that are patentable, things that measure the real world or perform actions in the real world are always very patentable. So if you're measuring something physical, if your operation is real time and synchronized to something else, then that works. If the data that you're processing is the results of real world measurements. I mentioned earlier that medical treatment and medical diagnostic processes aren't patentable. The sort of reasoning behind this, in Europe in particular, is that a physician should not be hampered in his work by the need to discern whether what he's doing to a patient is protected by a patent or not. So the equipment is perfectly all right because the physician and or the manufacturer of the equipment will have the patent issues. So any kind of novel medical device is patentable, and an awful lot of that happens. But you can't patent a new process. So if you invent a new method of heart surgery that uses an old scalpel, then that's not really patentable. But if you have to invent a new scalpel to enable the new method of surgery, then you can protect the scalpel. In terms of diagnosis, the exclusion is construed quite narrowly, and as long as you sort of stop, your methodology stops short of the point of saying, and the person has got a treatable condition, then you're all right. If you measure body mass index, your method comes out and says this person's got a BMI of 52, but you don't say and he's clinically obese, then you're not performing a method of diagnosis. So plenty of steps that measure heart rate, blood rate, whatever, are all perfectly patentable because they don't they provide an input to the diagnostic process, but they don't perform a diagnosis themselves. And also any method that is performed on a sample that has been removed from the person is perfectly patentable. So all of the sort of in vitro testing is all perfectly patentable. So what goes into a patent? I know one or two of you have had patent applications, may have seen them before, but a patent application can be a fairly substantial document. It starts off with just a general introduction to the field. What is the prior art, what has been done before, and we like to try and set the scene here and set up what the problem is and give yourself a grounding for an argument later about inventive step. The bulk of the application is what's called the detailed description. Starts with a list of the figures that are at the end, and that can be quite a substantial piece of work. It has to describe the invention in enough detail for somebody to put it into effect. And the pictures there are generally very useful. With the adage that a picture is worth 1,000 words, you can tend to try and get as much into the drawings as you do in the written description. It's usually not these days necessary to put software code listings, but occasionally if an invention really is getting down to that level, you see snippets of pseudocode or something that's fairly comprehensible. Now, the most important part of the invention of a patent application are the claims. The claims at the end seek to define what your invention is. They set out the features that distinguish your idea from the prior art, and what you would be unhappy if somebody else takes. There's an abstract provided for searching purposes, but we tend not to pay much attention to that. So how do the claims work? The claims are the patent attorney's attempt to define your invention. So they kind of work on a set theory basis. A claim defines the set of all things that are your invention. So it lists the features that define your invention, the processes, the steps of the process, or the physical parts of an apparatus that are necessary and essential to your invention. But we need to try and make the claim as broad as we can get away with, and we generally will start by claiming everything we can think of, and then in the face of opposition from a patent office we'll kind of claw back from that. Because the patent process is a bit of a negotiation in a sense with the patent office about how much you can get. So if you have a claim that says my car has 4 wheels, ABS brakes and a windscreen wiper, then any car that's got 3 wheels doesn't match that claim and therefore falls outside it. So in a sense, the more features there are in your claim, the fewer things there are that have all of those features, and therefore the narrower your claim. The major things that we can claim are anything physical, apparatus, products, systems of this, chemical entities, not so relevant here, but also methods and processes for doing things, whether that be in the real world or in a computer or both. We can also claim computer programs themselves, subject to the fact that that computer program must do something technical. As a sort of negotiating process, in a claim we start with our main broadest claims, and we have what are known as dependent claims that add more features, and we have to put these in at the beginning, but they're basically sort of subsequent lines of defense. If our broadest claim is attacked, we try and set out the ground that we're going to retreat to later. So the patent procedure is a relatively long one. It can take anything up to 5 years to get a patent application. I do still have some in my shelves that are going around for 8 or 9 years, 10 years, but that's sort of unusual. Sometimes things get mired in argument. Sometimes clients want the patents in a hurry, sometimes they don't. So things can sometimes be deliberately delayed. So before filing, so before we've got our priority date, a sort of general process would be that somebody identifies that they've made an invention, talk in a university environment to a tech transfer outfit, have a meeting with an attorney, with me. I draft a patent application, the attorney, the inventors review it, we get some amendments. I've always find if I draft a patent application and send it off to the inventor the first time and they come back and say that's fine, I say you haven't read it, have another go. There's always something to be improved, and you know, the process should be iterative. Hopefully not too many iterations because that drags out the delay and cost, but there is always at least one round of iteration. So then we file the patent application at the local patent office, and usually we'd use the UK Patent Office, or the IPO as it now calls itself, to establish our priority date. Even if ultimately we're not interested in protection in the UK, or we think the UK Patent Office might be hostile to this invention, we just use them to establish the date, because they're cheapest. So once we've got our priority date, we have now started our clock running. We've got our protection against other people inventing it later, but we have set ourselves a bit of a countdown. And the countdown is referred to as the priority year. There is an international agreement called the Paris Convention that's been around for 100-something years now, which says that if you file a patent application within 1 year of your first filing, then those subsequent patent applications are treated as if they had been filed, mostly, on the day of your first filing. So this year gives you a bit of breathing space to decide on what you want to do with the invention, how far you're going to take it, what territories you might want to cover, and to a certain extent to decide whether the invention is viable or whether the products underlying it, the business model underlying it, are viable. So during that year, we would hope to get a search for prior art out of the Patent Office, and we've discussed that with you to have a better idea as to whether you're going to get a good patent out of it or not. You're probably continuing to do work on the technology, and it may be that if there are significant developments during that year, we file further patent applications as a top-up. But somewhere around 6 to 9 months into that year, we need to come to a decision as to what you're going to do next, whether you're going to continue with it and what territorial ambitions you have. So because a patent application is territorial, if you want protection in other countries, you need to file patent applications in other countries. Now there is a thing called the PCT, Patent Cooperation Treaty, which allows you to file what's known as an international patent application. And although this is administered by the World Patent or World Intellectual Property Office, WIPO, it does not get you a world patent. What it really does is buy another 18 months of time to develop. You get a bit of a search carried out for British originating inventions by the European Patent Office, and if you get a good output from that, it can significantly simplify the process of getting patent applications in other countries. But it really buys you 18 months. And that's quite a necessary 18 months in a sense, because when you get to 30 months now, 2.5 years from your original filing date, one hopes that you've got a licensee involved or some investors in a startup to give you the funds to file patent applications in multiple countries. The cost can be sort of £3,000 to £5,000 per country, and so if you have wide ambitions to world domination, then those numbers add up very, very quickly. And if you're going into countries like Japan or China where you need a translation, then if you've got a complicated invention with a chunky description, then those translation costs are significant. So after all of that, so this is getting on for 2-3 years time from your filing, you will start to really engage with patent offices as to whether your invention is novel and inventive. The patent office will carry out its own search of prior art. They issue some kind of report. The exact terminology differs from place to place. We would discuss that with you, address how we're going to deal with any objections that are raised, have an argument, reduce our claim, and so forth. And this cycle can go around one or more times. In a particularly difficult case, you can end up with hearings and interviews, but that's relatively rare. Eventually you'll get a patent, and unfortunately that sort of isn't quite the end of it, because there are generally opposition processes that third parties can attack your patent if they need to. Once you've got a granted patent, I'm afraid it's not set in stone. It is subject to third party attack, although the numbers are relatively low, sort of less than 1% of patents are attacked by third parties. So, that's run through quickly. I'm not sure how I'm doing for time. We're going to take questions now or later.
We've got plans to take questions later.
Okay. All right.
Yeah, right, great. Thank you very much, John.